Namaskar. I am Assistant Professor Kritika Dev from LG School of Law. Today we'll be dealing with another topic of Indian Evidence Act, and that is presumption. Now, presumption or to presume. Now, till now, I guess that is the most familiar term that you must have heard. I guess that is again just my. I'm just presuming. I'm just assuming, you can say. And then you have different kinds of assumption under the Evidence Act. Now, what kinds are there, and presumptions are being used under which circumstances? Everything will be seen under this very lecture. Okay, so here when it comes to the presumptions under law, the presumptions are of three types. The first one is may presume, the next one is shall presume, and the third one is conclusive proof. So when it is being provided in this through this very act that the court may presume a fact. Now the court may regard such fact as proved or may call for the proof of it. So it has two things. So it is not of a very obligatory nature. The court may either regard such fact as proved or can call for the proof of it from the other party. So it has both the options, right? The court has both the options. But when it comes to shall presume, and it is directed under this very act that the court shall presume a fact, then the court shall regard such fact as proved, right? The court shall presume until and unless it is not being disproved. So if there is no evidence being given by the other party regarding that very evidence, till then the court shall presume, shall take such fact as being proved. Correct? And when it comes to the conclusive proof, when it comes to this very fact, and a fact is being taken as the conclusive proof of another, then what the court shall do? The court shall regard such fact to be proved and shall not allow any other evidence to be given on that very fact. If one fact is the conclusive proof of another, then on that very fact, the court shall not allow any other evidence. So now, why have we read all these three kinds of presumption is because we'll be getting conclusive proof, shall presume, or may presume under these sections. So it is very important before we go on to those portions, it is very important to understand these very terms, and that is the reason we have actually stated those. Now, birth during marriage, conclusive proof of legitimacy. Now, what does this section says? The fact that any person was born during the continuance of a valid marriage between his mother and any man, or within 280 days after its dissolution, the mother remaining unmarried, shall be conclusive proof that he is the legitimate son of that man, unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been begotten. Now, what is happening under this very section? You can see in this very chart that firstly, it has to be a valid marriage between both the parties, between the father and the mother. Now, the marriage, it should be when the birth took place, it should be during the continuance of the marriage. The marriage should be in continuity. And even if that marriage has been dissolved, then there are two things which has to be kept in mind. The first thing is marriage had to be valid. Whether the kid has taken birth after the dissolution, then there are two conditions, and even before it, then the marriage has to be valid. That is a firm point. But if the birth has not taken place during the continuance of the marriage, and if it had taken place after the marriage has been dissolved, then the two conditions are, the first one, he should be born within 280 days of that dissolution of marriage, right? Or mother remains unmarried, and mother remains unmarried. So these both the things should be there, born within 280 days, and the mother remains unmarried. Of course, if the mother marries again and then there is a baby, there will be a question mark regarding the legitimacy of the child. So here the mother has to remain unmarried. And now when these things are there, then it is a conclusive proof of the legitimacy of the child. But though it is a conclusive proof, it is a rebuttable conclusive proof, which means that the key to the lock is given in the same section. And what is the key? Though section is a conclusive proof, but this is a lock, it means this is a conclusive proof of which court will not allow to give any other evidence. But as the key is being given in the same section, the court will allow to open this very lock only with the help of that single key, because it is a rebuttable conclusive proof. Now, what is that proof? Non-excess between the parties when the child could have begotten. It means if the other party, if the father proves that he had no excess when the child could have been begotten. For say if he proves I wasn't there for a complete year, as soon as it was dissolved, and even before it, if the kid is born, I had no access to my wife, so how could that child be mine, and how could that child be a legitimate child? So this non-excess is the only key to that lock which can actually rebut the conclusive proof which is given under section 112. Right? With this, let's move on to section 113A, which talks about presumption as to abatement of suicide by a married woman. Now, what happens under this section? There are these conditions which has to be followed. The first one, the death should have been occurred within 7 years of the marriage. Right? So, it has to be occurred, it should have been occurred within 7 years of marriage, and if shown that husband or relative of the husband has subjected her to cruelty. So before that suicide, she must have been subjected to the to cruelty, which actually forced her to commit suicide, and has to be within 7 years of age. Then the court may presume, not shall presume, the court may presume that the husband or the relative has abated the suicide. It is just may presume. It may even call for another other evidence. Court is not bound because may is not mandatory. So the court may presume. Right? With this, let's move on to the next section. Now here, section 113B of Indian Evidence Act, it talks about presumption as to dowry then. Now what happens when the question is whether a person has committed the dowry death of a woman? Now, what are the conditions which is to be there in order to prove that it was a dowry death? The first one is, these are the things which has to be there. Woman must have died, of course. It talks about dowry death, so woman must have been dead. Now, soon before her death, she was subjected to cruelty or harassment. Now, she before the death should have subjected to cruelty. Now, that cruelty should be in connection to the dowry, right? By that very person. Now, it is women must have died. It should be soon before her death, she was subjected to cruelty or harassment, and that cruelty or harassment should be in connection to the dowry. Then the court shall presume. So here, the court shall presume that such person had caused the dowry death here. Right? Okay. Now, section 114A. Presumption as to absence of consent in certain prosecutions for rape. Now, what is happening here is, it talks about the consent of the victim as to the sexual intercourse. Now, here, the first thing, in order to reach to any conclusion here, the first thing is there should be sexual intercourse by the accused, and it should be proved, right? Maybe by the sample of the sperms, right? That there had been a sexual intercourse between the female and that male as in that very accused, and it is proved. It is proved that they had sexual intercourse. Now, women states that she did not consented. Now, once when it is proved that she had sexual intercourse and she had that sexual intercourse with the accused, and then she says that she did not consented for the same, that sexual intercourse was not with the consent of that very female, then the court shall presume. Here it is mandatory for the court to presume, shall presume, that she did not consented for the same at all. She did not consented for that sexual intercourse. Right? So here the court shall presume that she did not consented for the same. So here by these presumptions, by the sections that we have dealt today, I guess the presumption under these sections are clear in your mind. And with this, I would like to again tell you that keep reading, keep revising so that it helps you in the next lecture. Till then, keep studying. Take care. Thank you.